Hello, everybody, and welcome to your free consultation on the B1 visa. I'm actually looking forward to this because I deal with a lot of people who think the B1 visa can do a lot more than it can, and it's no different than the clients I deal with in our employment law section who think that everybody in California is an independent contractor, not an employee. I'm laughing because if they read the laws and realized the punitive impacts of these things, they would really be surprised. But everybody kind of tries and gets away with things. Now, the first thing I'm going to tell you, I've been doing this for 27 years. People all day long say to me, well, you know what? I heard that somebody opened their business, ran a Salesforce, did this, that, and everything on a B1 visa, which is the visitor for business visa. There's a B2 visitor for pleasure and B1 visitor for business. Well, people get away with things. It doesn't mean that if the government knew that they would be okay. So it's just like you can get away with drunk driving. It doesn't mean it's right, and it doesn't mean that you shouldn't do it. You got away with it. But if somebody knew that, for example, a police officer, that you were doing it, things would be different. Same thing with a B1 visa. A lot of people get away with things, and the biggest way they get away with things is by lying to the border officer when they're coming into the country. It's just a regular thing. Oh, I'm going there to visit Orlando or see what San Diego or Los Angeles looks like, when really they're conducting business there. And you have to be very careful, because if you lie to an officer, you come into the country, you're coming in on a fraudulent basis, that could get you permanently barred from the United States. So the risks are very high. Let's talk about the B1, and let me explain to you what you can and cannot do. The B1 is visitor for business. You can look at businesses. You know, let's say that you're coming in to get an E or L visa, or you want to invest in an EB5. Those are the three investment vehicles. You can come into the country, have a look at a number of businesses, you know, meet the people who are selling them or the franchisors who are presenting them to you, and then make your decisions accordingly. Or even check out the city, see if you like the city for the kind of business that you're creating and it makes sense. However, when it gets to the point where you're conducting business is when you've crossed the line. And we just had this happen in a call. You know, not everybody hires us because there's not much we can do for a lot of people, or they don't want to spend the money. But we had a call the other day from a lady from Canada. And what she does is she comes here on a monthly basis, conducting seminars, getting paid for it, and then goes back to Canada. But she always tells the officers that she is coming just to visit friends. What she's doing is wrong. Now, there's a landmark case that, if you think about it, explains everything, and it gives you an idea of the concepts behind the B1 visa. It's called the Matter of Hira. It's a 1966 case. And I'm sure you may or may not have heard of it, but I'm sure you've heard about it if you've spoken to a lawyer. A Hong Kong tailor comes to America, measures your body. The work is all conducted in Hong Kong. The profits are accrued in Hong Kong. The payment goes to Hong Kong. All that the person is doing is measuring your body. That, the government stated, is perfectly fine. Now, it's a BIA case, Board of Immigration Appeals. Now, in another case, the Monet case in 1965, we had a painter. He was trying to bring paintings from another country, sell them to the United States, or in the United States. What is this person essentially doing? They're expanding their geographic limitations. They're setting up an office even if they don't have a legitimate office, but they're doing business, as it's called under the law, in the United States. So if you're conducting business in the United States, you will not be approved for what you're doing. And this person was certainly denied, because the person should have gotten an E or an L visa in order to do that. We had an engineer in 1965, the Neal case, same kind of a thing. They were trying to expand the demographics of who their clients were. So they moved, some operations to the United States in order to do so. And as soon as they started conducting work here to start bringing in more clients without applying for an E or an L visa, Well, of course, they got caught and things didn't go very well, and now it's one of the landmark cases in this area. So, long story short, the B1 visa allows you to analyze the business climate in the United States, analyze the geography, the demographics, who's there, can an office work if I open it up in Sacramento? Should I be in Los Angeles instead? Should I be in San Diego conducting my business? What makes sense? But once you start conducting business, if you're not applying for an E or an L visa, an E is a treaty investor visa. We've created a program for you on that, where a video which you're welcome to look at. And L is intra-company transferee, where you open a branch, subsidiary, or affiliate of a company that you have in any other part of the world. Then, if you're not doing that, or even applying for the EB-5 green card, where you have to invest at least $500,000, then you're doing something that's unlawful under the American laws. And one of the things that you have to be very aware of in immigration, which a lot of people aren't, because we also conduct business law. And in business law, the nice thing is, most things are in black and white. A few things are open to interpretation. You've got to keep the courts full somehow. But a lot of things are in black and white. We understand them. If we're going to try a case in court, we have an idea of the range of what exactly a judge or jury may think of. In immigration, it's very, very different, because a lot of your case is going to depend on the officer that you get. You're not going to get a judge, you're not going to get a jury, you're going to get an officer, and depending on his or her experience for certain matters, your determination will be based. And that person may bar you from the United States for life. Now, of course, the bar on your passport may say 5 years or 10 years or something like that. However, realistically, having done this for like I said, 27 years, I find that people who were barred a long time ago and then make a reapplication tend to be denied. Why? Because unlike the case where, sometimes we have to defend somebody who made a mistake when they were young, didn't think about it. Here you have a person in their mid-30s or mid-40s. They conducted a business mistake, but 10 years later, they're still the same person, still doing business in the same field, still, really essentially the same zebra with the same stripes. That person's no different. So they're probably going to try and get away with something else again. So why bother letting them in? Why not let in the person who doesn't have a record for abusing the immigration laws? So in summary, what I would suggest, if you're not sure on whether what you want to do is something that's covered by the B1 visa, consult with an attorney. Find out or read the laws on your own, but be careful what you read on the internet. A lot of it is not written by lawyers, and it's not necessarily accurate. I get this all the time. Well, I read in such and such a website that I can do that. And no, it wasn't written by a lawyer, and it's actually not true. So be careful. Plus, immigration changes feverishly because it's federal law. So anything that happens in Alaska can affect San Diego, for example. It doesn't matter where, it's federal law. So really, at the end of the day, if you want to use a rule of thumb, if you're doing something that really is creating profits, creating business, expanding your business in the United States, you cannot do that with the B1 visa. The nice thing is the United States offers you a number of options in terms of visas and ways of entering the country, but you just have to apply for the right one. But to just think that B1 is called a business visa, it's visitor for business, not a business visa, as many people tend to call it when they call me. Doesn't mean you can come here, run a business, create a business, do whatever you want, and not apply for a subsequent visa. For example, you may want to come in here, make an investment into a business, and in the meantime be applying for an E or an L visa. That's one thing. But if you're simply coming here trying to conduct business in the United States and create a source of profits and revenue, obviously, it's not going to work for you. So be very careful. It's a very limited visa. But the most important thing that I can tell you, be honest with the immigration officer at the border, because they can find out what you stated that you would do. And if it contradicts why you were let in, you've now got premeditated fraud. And premeditated fraud is really hard to win because it shows that you knew that it was wrong, you planned, your comment, statement, action, and then you went on with it. So I hope that I've answered a few questions with respect to your what would I call it, dilemmas with the B1. It's not anything I can do in business in the United States visa. And again, think about the Hong Kong Taylor case, the matter of HERA, BAA 1966. Come in, measure, get out. But to come in and actually conduct work or expand your business or come in on a regular basis to work, it's not what it's meant for. Good luck in your journey. Cheers.